argument time requested, so only ask for the time that you really need. Lee versus City of New York. I see two people here, but the appellant didn't request argument time. Are either of you here for the appellant? No. Are you the appellant? I would have been the one who granted it, and I never granted argument time. I never got a request for argument time. Are you familiar with this? I'll give you each 2 minutes, and if we have more, we'll ask for more, because my understanding is that the brief didn't have any request for argument time, and I've never received a request for argument time, but I'll give each of you 2 minutes on this case. MB Financial versus 56 Walker, appellant? Are you appellant? Yes, I am. Okay, how much time are you requesting? Total of 8 minutes. Respondent? 5 minutes. 4, 1, and 4. Feiger versus Ray Enterprises, appellant?
Good afternoon, Your Honor.
Good afternoon.
4 minutes plus 1 for rebuttal, please.
Respondent?
Respondent, yes, Your Honor. We had requested 15,
4, 1, and 5. People versus Fishbine, appellant? Respondent? 7, 1, and 7. Pino versus Gimenez, appellant? What? I said good afternoon. Good afternoon. Requesting 8 minutes, Your Honor, 2 minutes. And I know there are 2 respondents in this case? No, I'm not going to give it to you either. Respondent?
I'm the second respondent, Taurus and Autorama, 3 minutes.
Okay, 5, 1, 5, and 3. And again, if we have more questions, we'll keep asking. CLSA Americas versus Mayo, appellant?
Appellant requests 4 minutes and 2 minutes, please.
Respondent?
Good afternoon, Your Honor. Respondent requests 8 minutes.
4, 2, and 6. Moyes versus the Chapen School, appellant?
Appellant, 4 and 1.
Respondent plaintiff, 6 minutes, please, Your Honor.
And city respondent, 5 minutes, please.
Did you submit papers on this case? Okay. 4, 1, 6, and 5. Rational Special Situations versus Bank of New York Mellon, appellant?
Appellant, we requested 15, we split 12 free.
Okay. BNY? And Sincora?
Your Honor, good afternoon, Mark Goodman, 5 minutes for support, Your Honor.
Okay, 6, 1, 5, and 5. Hassan versus New York City Health and Hospitals has been withdrawn. Stewart versus Prospect Transportation, appellant?
Appellant, Your Honor, 4 and 1, please.
Respondent?
Respondent, 4.
4, 1, and 4. Santiago versus Genting, which I know has 4 parties and 3 appellants.
Respondent, Genting and Plaza, request 5 minutes, Your Honor.
Okay, and the other 2 parties, oh, I see. What? Is the plaintiff here? Oh, you're the plaintiff. Did you have, you had a cross appeal? Okay. Okay, 5, 1, 5, 1, and 5, 1. People versus Acosta, appellant? It's submitted. Hernandez versus Piccardo, appellant?
Appellant, Your Honor, 6 minutes and 2.
Respondent?
Respondent will take 6 minutes, Your Honor.
I'll give you 5, 1, and 5, and again, if we have more questions, we'll keep asking. Okay, the first case for argument is Lee versus City of New York. Go ahead.
May it please the court. Chelsea Shia from Mobilization for Justice, representing the appellant, Mr. Lee. Mr. Lee is a Chinese immigrant who was dropping his friend off at the airport when he got caught up in an undercover TLC operation. The underlying oath hearing decision should be overturned because there is no substantial evidence showing that Mr. Lee used his car as a for-hire vehicle that day.
Why
First,
should we disturb the credibility determinations that were made below as to the evidence finding that there was a violation?
Yes, while generally deference is given to credibility determinations from the trial judge, they can be overturned if they were made against the weight of the credible evidence. The Oath Appeals Unit has done so in the past, and this court has the authority to do so here.
The evidence here, the two officers, between the two of them, they testified, or they showed that there were two men who gave the plaintiff's license plate number, and then when the plaintiff came to the airport, that license plate number matched. Is that correct?
Yes.
And then there was a series of text messages on a We app indicating that the plaintiff would pick someone up at the airport. Is that correct?
Yes.
What is the evidence that's missing?
Yes. So Mr. Lee never discussed setting a fare with the undercover TLC officer. The only time that a fare was mentioned was between the two men who solicited the officer and the undercover officer at the airport. So these two
There
men...
was other indication that when the officer asked Mr. Lee whether or not he was a taxi, he nodded affirmatively?
According to the undercover officer's testimony, that is what he says happened.
So there was a lot of credibility issues.
Well,
Is that reviewable by this court?
I would say so. One major piece of evidence that the hearing officer discredited on review was a sworn affidavit that Mr. Lee presented from his friend, who stated that he dropped her off at the airport that day so she could catch her flight back home to Florida. This was a favor that was being done for a friend. The hearing officer chose to discredit this, all because Mr. Lee did not have photos of him and his friend together.
Thank you very much.
Thank you.
May it please the court, Your Honors, Jeff Kerfman on behalf of the Taxi and Limousine Commission. As Your Honors alluded to, this case comes down to well-reasoned credibility determinations.
But there was nothing in the record that said that the officers actually spoke to Mr. Lee about the price for a fare, and that would be something that you would normally expect to see if someone's going to give someone a ride in terms of a taxi situation.
A couple points, Your Honor. The first, as you alluded to, even if there was no discussion of a price, there was acknowledgement by Mr. Lee in testimony that was credited by the hearing officer that Lee was acting as a as a taxi, and I think there's a reasonable inference from the use of that word that Lee understood this was an arrangement to operate on a for-hire basis for a fare. Secondarily, Lee offers no evidence for his proposition that this was a setup, and he doesn't have any explanation for sort of an extraordinary coincidence where he arrived at the precise location where men at the airport told Officer Sue he would arrive at the exact time they said he would arrive.
What about the affidavit from his friend that said that she was just dropped off by him as a favor to her at the airport? I mean, that's an explanation.
A couple points. Number one, even conceding that Lee had a friendship with the person he dropped off, that doesn't change the fact that there is overwhelming evidence he engaged in a for-hire arrangement on his departure from the airport when he picked up Officer Sue. And secondarily, the hearing officer appropriately found that Lee wasn't able to present any other evidence indicating an actual 3 to 4 year friendship with this person when asked on the stand.
Thank you.
Thank you, Your Honors. We ask that you affirm.
MB Financial Bank versus 56 Walker. It's your case, right? You should come up then. Go ahead.
May it please the court. Respondent's attorney willfully and knowingly misstated in paragraph 5 of his affirmation in support of summary judgment that an amended complaint was filed with the clerk on April 28, 2011. That complaint was never filed, nor was a motion to file an amended complaint out of time ever made as the docket shows. Hence, there is no authenticated amended complaint that is admissible to support summary judgment required by CPLR 3212B. Instead, respondent's attorney intentionally fabricated a pseudo-amended complaint that does not bear the clerk's stamp, but uses a stamp like this that I bought at Staples for a few dollars. Nor is it marked up to show changes from the original complaint as required by CPLR 3025B. Respondent's motion to add INN as a defendant was denied. It was therefore fraudulent to add INN's name as an additional party in the supplemental summons and in the judgment, and they did not pay the fee to add an additional party in the supplemental summons. It was therefore error not to grant appellant's motion to vacate the judgment. Respondent attempted to add Labanco as a defendant by filing motion number 22. It was denied, yet Labanco was evicted. This court has long held there can be no question that a judgment or award obtained by false testimony fraudulently given by the party benefited, therefore is voidable. That was in Nugent versus Metropolitan, 46 AD 105, 110, from this court, 1899. The equitable maxim that no one can benefit from his own wrong applies. The motion court ignored the law by ignoring the foregoing arguments made so many times that appellant was sanctioned. Appellant respectfully seeks a reversal of the order denying renewal and the vacatur of summary judgment against INN and all other defendants. I also seek that the case be remanded with an instruction to restore INN, Labanco, and 56 Walker to the status quo ante. Thank you for your attention, Your Honors.
Thank you.
May it please the court, Joseph Mayo for respondent MB Financial. Your Honors, I think it's important to start with what actually is appealable in this case and what is not. The appellant purports to appeal 3 different motion sequence numbers 37, 38, and 39. Most of the arguments you heard from appellant today were raised in motion sequence numbers 37 and 38. The appellant did not perfect those. He noticed appeals from those orders, but did not perfect them within 6 months. And therefore, those issues are waived and they're not properly on appeal. The appellant did perfect his appeal from his denial in motion number 39, which is for motion for leave to renew or re-argue. Now, a motion for leave to re-argue is not an appealable order, so that leaves only his motion for leave to renew. And the standard, as Your Honors know, on a motion for leave to renew is that the appellant has to point to, or the party has to point to, new evidence that was unknown to the party before making the motion, and that evidence would have changed the result in the prior motion. And the appellant cannot meet either of those standards, Your Honors. Number one, the only new evidence that the appellant points to in his motion for leave to renew is affidavits from Mr. Labanco and from Mr. Morris. But those affidavits state that they assign their rights.
You don't attach the assignments.
They're not attached, exactly, Your Honor, which is why they're not competent evidence anyway. But in any event, those affidavits say that they made their assignments before appellant filed his original motion. So by definition, that's not new evidence. But as Your Honor notes, in any event, that wouldn't have changed the result for a number of reasons. One, It's not new evidence. Two, all of the assignments post-dated the order that that appellant is ultimately trying to vacate and therefore is void. The remaining arguments that appellant makes, as I alluded to before, Your Honors, were not preserved for appeal. Predominantly, appellant's argument is that the original amended complaint in this case was a forgery. That is an argument that the appellant made in motion sequence numbers 36, 37, and 38. And as I think appellant noted, he made it numerous times. None of those orders were preserved for appeal, and therefore they're not properly before this court.
Thank you very much.
Thank you, Your Honors.
You have a minute to respond if you wish.
Your Honor, it's my understanding that in New York, oral assignments are perfectly valid. The motion to renew was because my standing was questioned. If I didn't have standing, I had no argument to make. So the affidavits reinforced that my original assignments, which were filed with Judge Ewing, were valid. And based upon restoration of my standing, I made the arguments about the fraud, which Respondent's counsel has not denied. He can't deny it. There's no motion for leave to file an amended complaint on the docket. They entered judgment against INN, who they made a motion to add INN as a defendant. It was denied. They nonetheless added INN as a party under judgment. This is a case of fraud upon the court, and I would ask in the interest of justice that the court review the entire record as is relevant to my appeal. Thank you.
Feiger versus Ray Enterprises.
Good afternoon, Your Honor. This case is an appeal of a summary judgment decision. The trial court decided the case on an issue that was not even properly before it. The moving party never raised the issue of arbitration, and that was the path that the lower court took. That's problem one. Problem two.
What's your argument that they didn't raise it? They didn't make any argument that there was an arbitration of these issues and therefore it shouldn't go forward in the court?
It's a subtle point that the trial court may not have seen and overlooked. An arbitration was started. My client, Ferguson and RJ Group, filed claims against the person who started it, Schneider, but it was never completed. There was never a
You say it was
hearing.
never completed, but it's undisputed that both parties asserted claims in that arbitration, and that arbitration ultimately resulted in the sale of Maxwell's only asset and the dissolution of the LLC. So what is the basis for your argument that it wasn't resolved?
Well, what Your Honor focused on is only part of it. There were claims, contract claims, tort claims, that were part of the whole arbitration proceeding that were not adjudicated. So the little part of it that had to do
You were
with...
there, you had every opportunity to participate in that arbitration, and not you, but whoever was there. And it's undisputed that the agreement is unambiguous and provides that all claims are to be resolved by arbitration.
That particular point is not in dispute. It's not a point, it's not an argument over whether that is required. The whole question comes down to, is it a viable forum? The AAA suspended it because of non-payment of fees. It was not viable. It was suspended.
But there was a resolution because there was a dissolution of the LLC and a sale of the only asset. So it did come to a conclusion.
No, once again, that's just a small sliver of the whole global world of dispute. There were claims, fiduciary breach claims, contract breach claims, tort claims. They were never heard.
So why didn't you bring another arbitration? You had just as much right to initiate an arbitration if there's an arbitration clause that covers all issues. Why should the court be hearing it if there's a clear, broad arbitration clause which says all disputes of any nature are to be resolved in arbitration?
before my time runs out, let me just say, assuming that is correct, arbitration was waived by the responding party. They've been litigating for over 10 years.
What's the basis for your argument that it was waived?
Because Schneider didn't pay for arbitration. He started it and he stopped paying it because things were not going well for him.
So why didn't your client pay?
There's not an absolute duty that he has to cover the other person's fee. My client did pay. My client paid for his share. Yeah, he did. There's nothing in that operating agreement that says you, co-owner, must foot the whole bill and pay for the whole thing. That is the key point. That's the background for this whole thing. Schneider started it. He stopped paying, and the whole thing was suspended with nothing accomplished.
Maybe he stopped paying because he already achieved the result he needed.
He achieved the result he wanted of driving the company into a ditch. Yeah, if that's the result he wanted. They waived arbitration, Your Honor. They've been litigating for over 10 years. They didn't come back. As soon as this thing was in Supreme Court.
Well, the case in Supreme Court wasn't really about this. I mean, that's why this case came up here before. The case in Supreme Court was about a completely unrelated company, and your client put in cross claims having to do with this case, but that's not what this case was about. But I'm going to let you respond and reply. I'm going to let you respond and rebuttal.
Okay.
Okay, because you have more time to rebuttal.
May it please the court, Lisa Fantino for respondents, Vladimir Schneider, and
You addressed the issue about whether or not there has been a waiver of arbitration by their failure to pay the fees in the arbitration. Why doesn't that constitute a waiver which allows them to proceed here in this action with the cross claims?
well, as Your Honor is aware, because Your Honor mentioned Article 7 of the operating agreement, it expressly states that all dispute resolution must be in arbitration.
Right, but they're making an argument that by the failure to continue paying the fees, the arbitration ended up being discontinued, and that effectuated a waiver of the right to arbitrate these claims. So what's your specific response to the failure to pay the fees in the waiver argument?
Well, there's two things that they've alleged waive arbitration. The first is that Mr. Schneider has litigated for 10 years. He's not the plaintiff.
No, but I'm asking you a specific question about the non-payment of the fees, which is what caused the arbitration to be discontinued, according to...
Once the asset was sold, it was Mr. Ferguson that wanted to continue the arbitration. Mr. Ferguson could have paid those fees. There was nothing either in the arbitration clause of the operating agreement or in the AAA's rules that required both of them to share. If he
You're
believed,
saying your client had no obligation to pay half of the fees, and that if they wanted to proceed, they could have just paid all the fees themselves?
correct, Your Honor, yes.
Anything else?
Well, there's the issue of threshold preclusion. I mean, they should not be able to get across the front door of any courthouse, whether it's a New York courthouse or a Delaware courthouse, because of the fact that they chose contractually. The parties are intelligent, savvy investors. This was their agreement that said, we don't go to court to resolve our disputes.
Right,
No,
but,
just- go ahead.
but that's two-sided, isn't it? I mean, your side also agreed to go to arbitration, then unilaterally decided you're not going to pay for it.
Because he believed that his claims were settled. If Mr. Ferguson chose to pursue additional claims, it was up to him to then,
So the agreement just said it was silent as to payment. So you interpret it as I only pay as long as it's as to my advantage and is dealing with my issues.
well, Your Honor, if I may, there is a history of Mr. Ferguson not being cooperative, and there were fees that needed to be paid, especially to the liquidating trustee who sold the property, that were never paid. In fact, at deposition, which he was granted discovery on these 6 cross-claims, that liquidating trustee testified, and they did not use
Did they
it.
pay for the arbitration up until the point that you stopped paying?
No, they did not. There were fees that were still due, and they did not.
No one paid the arbitrator.
I'm sorry?
No one paid for arbitration?
No, they both did to a point, but then once the property was sold, the liquidating trustee also had to be reimbursed. Mr. Schneider paid for his fees, Mr. Ferguson did not, which is exactly what the liquidating trustee testified to.
Thank you. Any
Thank
other
you.
questions? Thank you.
Thank you.
That last point, let me just address quickly, is a false path. It's got to do with paying a liquidator. That's got nothing to do with the
But
arbitration
did the
panel
arbitration
itself.
agreement say anything about who had to pay the fees for the arbitration? Or were the AAA rules specify who had to pay for the arbitration fees?
Generally, each side pays a portion, half
Was
and
there
half.
anything specifically in the operating agreement or in the AA rules that mandates that each side pay for 50% of the fees? Because your argument is that they stopped paying the fees and therefore they waive. So for that to be a valid argument, there has to be some obligation on their part to pay the fees. So that's what I'm trying to get at.
I don't have that in front of me, but the general gist of it all is that each side pays their share. There's no,
So
from
you
my
don't have any
recollection.
support, is there any support for that statement that each side is required to pay their share of the fees?
Common sense and equity. The thing is, there's nothing in either AAA rules or the operating agreement that says you, Ferguson, shall pay 100%. That is not in there anywhere.
It doesn't say
And if it
anything
were, they
about
would
the
have brought
fees.
it up anyhow.
Okay, thank you very much.
And let me just address one
No,
final,
no,
I
no,
never answered your question.
your time's up, Council. Thank you. But we're familiar with the record and we'll look at it. People versus Fishbine?
Good afternoon, Your Honors. Samuel Barr for Appellant Michael Fishbine. This was not a fair trial. The jury that decided Mr. Fishbine's guilt was 3 times misinformed about the presumption of innocence, the bedrock of our criminal justice system. The jury was told most egregiously that, quote, only for the prosecution's case is the defendant presumed innocent.
Did the court ever explicitly change that mistake?
No, Your Honor, the court never explicitly revised or corrected that error. What the
Court
court,
ever explicitly even state that it had made an error?
no, Your Honor, what the court did was insufficient. The court merely, the next day, in the middle of a witness's testimony, the parties have already given their their opening arguments under this erroneous instruction. The next day, the court gives an improvised, purported curative instruction in which she makes no reference whatsoever to the error and merely in the course of this charge does state correctly that the defendant is presumed innocent throughout
That's
these
what the law,
proceedings.
what's the standard for what the law requires? If a judge makes an error, what's the judge then required to do to have an effective curing of that error?
I would refer to Your Honor to People v. Wood from the Court of Appeals in 1985, which is cited in our main brief, which says the judge must promptly and clearly tell the jury to disregard, completely disregard.
And is there any evidence in this record that this judge did that?
No, Your Honor, the judge absolutely did not do that.
What about your adversary's argument that to highlight that would confuse the jury?
The cases from this court and from the Court of Appeals are completely to the contrary. It is the responsibility of the judge, as I said, to clearly and promptly advise the jury to completely disregard the error. And if the court had told the jurors that, then we are to presume that the jurors would follow that instruction. But jurors are not to be left to their own devices. They cannot be assumed to follow 2 inconsistent instructions without being told this is the correct one and that was the wrong one, which they were never told. If there are no further questions, I could touch briefly on my Brady point and my Gizendander point.
It's your time.
Great. So especially in light of this unfair charge, it was egregiously wrong for the defense to be prevented from obtaining this former officer's disciplinary records. Just to focus on the Gizendander, counsel cited 2 pending lawsuits involving excessive force. My client's claims, which he testified to, were that this officer was engaged in excessive force and that explained and justifies his own actions. 2 prior lawsuits involving excessive force, and Judge Klott wouldn't hear it, couldn't even conceive of the basis for ordering.
Was there some reference that one of these cases involved a shooting and it was accidental? I mean, Was that a basis?
That was ultimately what was revealed about that incident, was that the NYPD investigated and found that it was an accidental shooting. But still, nevertheless,
That
even
was an NYPD finding, right? That wasn't a civil court finding.
correct, it was an NYPD internal finding. But that wasn't before the motion court. What was before the motion court was just these two lawsuits involving excessive force and a defendant trying to suggest that this officer, who we now know did have a serious violence problem, did have a serious credibility problem, that he had had prior discipline. And because that was denied and the court didn't even review the materials in camera, let alone what to make of those, didn't even subpoena and review them himself, we never learned that 3 years prior to trial, this officer was docked 45 days vacation pay, which is...
With regards to that, I think I read somewhere in the record, correct me if I'm wrong, that there was a representation made by the people to the judge that they had researched the disciplinary records of all officers involved in this case and that the results were negative.
Correct, Your Honor. The people did represent that, and without casting any aspersions on the good faith of the prosecutor.
That was just wrong.
That was flat out incorrect. There is no way to make that representation and not to have at least done a massive disservice to the court and to the defense in this case. To have claimed to have checked for the complainant officer's disciplinary records and to have found none when 3 years earlier, in fact, I looked back at the exact dates, it was only 3 weeks after this officer got off his year-long probation that this incident occurred with Mr. Fishbine. And yet Mr. Fishbine was prevented from telling the jury that this is a problematic officer with a history of violence, a history of misconduct, a history of discipline, and that requires reversal.
Thank you.
Good afternoon, Your Honors. May it please the court, Christian Rose for the people. If I could briefly start with the Brady-Gissendiner claims, because I think our response is quick.
Let's actually start with the court's error about the burden of proof. That seems like a very basic fundamental issue, and there doesn't seem to be much dispute that the court did make an error in the way she instructed the jury about the presumption of innocence. And the standard clearly requires that it must be withdrawn in explicit terms when an error is made. And is there anywhere in the record where she ever withdrew in explicit terms the error that she clearly did make 3 times in jury selection?
So obviously several things to unpack there. I mean, if I could start about the standard, because I'm sorry, Wood is just not the right standard. That's a case about prosecutorial misconduct. Drake and Harrison are the Court of Appeals cases that actually have to do with whether an instruction is erroneous and what needs to be cured.
And Harrison does go on to say that it has to be withdrawn in explicit terms.
Right, and so I think that Harrison is actually very instructive in this case. So
Well, that was the standard I just referred to in my question, was the Harrison standard, that has to, and that was my question to you, that it has to be withdrawn in explicit terms. And I don't see that. So I'm wondering what you could point to where the judge ever did withdraw in explicit terms her erroneous instruction.
So the point about Harrison is just to put the case in context, and I can explain how the court did cure any error if it existed here. So
Wait a
If
minute,
it existed?
if it existed, are
Well-
you not conceding that there were errors made?
well, I think Drake makes
That's pretty incredible.
Well, I think that it's certainly true that there are comments that Justice Jackson makes.
Counsel, I mean,
There were instructions on what happens to the presumption of innocence if the defendant testifies that was clearly erroneous. How can you stand there and say otherwise?
If you read the statements in context, I think what she's trying to do is she's trying to dispel the notion that was put forward by defense counsel that the presumption of innocence.
She says it 3 times, unambiguously states the incorrect standard for the presumption of the burden of innocence.
So
so let's just start from that starting off point, right? Let's all understand that errors were made. Where in the record were those errors explicitly corrected?
So they're corrected 3 times. The first is in the preliminary instructions where the court gives the correct standard about the.
I'm sorry, where they were withdrawn in explicit terms and then corrected.
No, so I want to make clear that there's no case that says that in the Court of Appeals case in the Court of Appeals and in this court that a jury has to be told to specifically disregard a prior instruction. What happens
I think that's what Harrison exactly says, that the error must be withdrawn with such explicit terms.
Right, and so in Harrison, what happens in Harrison is the court gives an erroneous instruction about essentially leading them to, in a situation where they could have returned a repugnant verdict. And the jury begins deliberations, the error is drawn to the court's attention, and the court does not explicitly say that it was previously wrong, but it just gives what the Court of Appeals describes as a path in which the jury could have found the right, could have come to a correct conclusion. But the issue that the Court of Appeals stresses in Harrison is that because the jury had already begun deliberating, it couldn't be clear that the prior erroneous instruction was not already relied on in deliberations. That's why a year later in People v. Ladd, also cited in our brief, the court gives an erroneous instruction at the beginning of deliberations, at the beginning of its final charge, is objected to, and then the court gives the correct.
Counsel,
I really have a hard time with your.
We can't
listening to
really
your
hear you.
argument. I'm saying, can you hear better now?
Possibly.
Not really.
Okay. I will talk as loudly as I can, all right? Okay. I have a hard time with your argument or your apparent argument that the presumption of innocence does not continue when a defendant testifies in his own right. Is that what you're actually saying?
No,
Because Harrison is explicit in that the erroneous instruction has to be withdrawn in such terms as to preclude the inference that the jury might have been influenced by it. And then our sister court in the Third Department said the withdrawal of an erroneous instruction is accomplished by a candid admission of error and by a clear and forceful and accurate curative instruction. Are you saying that doesn't have to be done?
No, and there's no Court of Appeals case law or First Department case law that says so. I mean, I don't want to go through the facts of each individual case because they're outlined in our brief, but I think I would just encourage this court to look at for People v. Ladd and People v. Drake, where there was an erroneous instruction in the court's final charge, which, by the way, this was not the court's final charge.
We're talking about the most, in my view, fundamental right enjoyed by the criminal defendant, the presumption of innocence throughout the proceeding. And a mistake is made, not at the end of the case, but at the very beginning of the case, during jury selection. That's the lens through which they're going to view this case. And we seem to need to contort certain principles out of Harrison, such as the need for an explicit withdrawal or acknowledgement of the mistake and then a clear correction of the mistake. We seem to be asking you to do an awful lot here to overlook this.
Well, I think there's 2 points to that question. The first is that with regard to the lens through which they view the case and being a fundamental principle, absolutely, it's a fundamental principle of law. But I think that because the idea of the presumption of innocence is so common and straightforward, it's actually less harmful here.
The jury should just know that the judge was wrong and was giving the wrong instruction?
No, because the jury's hearing...
There's a presumption of innocence? Is
the
that
jury's
what you're
hearing...
arguing?
The jury's hearing, and sorry, I should be clear, this is not the jury, these are prospective jurors are hearing these comments that are in direct response to counsel's statements about whether the presumption of innocence enhances credibility. And then when the trial actually begins, the jury is instructed 3 times, including explicitly told whether or not the defendant testifies. He is presumed innocent. And I think that at the very least that
We're
instruction...
obviously all struggling with, though, is that there was never an explicit withdrawal of the erroneous instructions. That's what we're all grappling with here, and none of us have really heard a response from you how to deal with that.
Well, if I could answer your question try one last way, which is that the explicit withdrawal has never been required by the Court of Appeals. And the 2 cases that we cite...
You're saying it's the wrong legal standard we're talking about.
It's not the wrong legal standards that the defense has put forward that is interpreting, overreading Harrison, which I think is clear from Ladd and Drake, which both come after Harrison.
Thank you very much. Thank you.
Very quickly, Your Honor, I just want to refer back to People v. Kelly, 1951 from the Court of Appeals. We cannot assume that the jurors faced with 2 opposite and mutually exclusive charges as to the rule had the wit and ability with unanimity to adopt the right one and reject the wrong one. This is not a Third Department principle, although it's also invoked in that court. This is a Court of Appeals principle that we are invoking here. the court was required to correct explicitly its error. And just one final word, the idea that the defense counsel invited this error, even granting the defense counsel was stretching a bit. The proper cure was to say, as the court initially did, everybody is evaluated as to their credibility. But to then go on and to 3 times undermine the presumption of innocence requires reversal.
Thank you very much. Pino versus Javier.
Good afternoon, Your Honors. May it please the court. My name is Andrea Soto. I'm here for the plaintiff appellant, Jacqueline Paulino, who's the administrator of the estate of her husband, Lionel Paulino, and Ms. Jacqueline Paulino individually. Your Honors, I'm here before you today. We did bring an appeal, just 4 points, Your Honor. The lower court improperly granted summary judgment to the defendants, specifically Ermino Torres and Autorama, as well as Juan Xavier Gimenez, based on self-serving affidavits that were provided.
Why don't we talk about each of the defendants separately, since there really are very separate arguments. One of them was a tow truck.
Yes.
And one of them was the driver of the car that was stalled on the
Yes, Your
highway. So
Honor.
it's a different analysis. So why don't you focus on each separately?
Yes, Your Honor. Both defendants did say that they did not proximately cause the accident. I just want to point out to the court before.
What's the basis for liability against the tow truck?
Well, the tow truck was unauthorized on the Cross Bronx Expressway.
What's your basis for saying that the tow truck was unauthorized?
The New York City laws, the vehicle and traffic laws, require that for any tow truck to operate in the city of New York, they have to be called by the NYPD, meaning me being a person who has an accident on the Cross Bronx Expressway cannot call my own tow truck. Now, this gentleman did not call 911. He called Autorama, and they showed up. They were unauthorized on the highway.
Isn't this analogous to a driver's license? The lack of a driver's license only relates to the permission to drive, not the manner in which the vehicle was operated. Is that analogous here, that whether it's authorized or unauthorized, the vehicle, the facts are what they are about where it was positioned, whether the lights were on, et cetera?
Well, Your Honor, actually, there is a difference, and it matters to be authorized as a tow truck in the city of New York, because it's our understanding and our position that Autorama's tow truck was ineffective and it was defective. It didn't have proper lighting. It didn't have it didn't do the proper procedures with respect to.
Your argument that it didn't have proper lighting, or that the lights that it had were not activated?
No, there was no proper lighting. There were lights on the tow truck, and they were.
It's not enough.
They're just not enough, and because they weren't enough, my client slammed into the right outermost portion of the flatbed truck, and he was guillotined. His brains ended up on the middle of the Cross Bronx Expressway. My client is now a widow. She's a young widow. She was about 35 years old when this happened.
You're not deciding it based on
Counsel,
that. Why don't you focus on the case?
Can you back up a second? As far as the being an unauthorized tow truck, what did the police accident report or incident report have to say about this? Was the tow truck described as authorized or unauthorized?
The police accident reconstruction report indicated that it was unauthorized, and it also made
No. The police.
There were 2 police reports,
Police
Your Honor.
report itself, yeah.
The police report itself indicated that it was unauthorized. In addition
I'm looking at the police accident report,
as well.
and didn't it say authorized?
I don't have the police report in front of me, Your Honor. There was an
It says
extensive accident reconstruction report. However, it was noted that the tow truck
I'm
was
looking-
unauthorized.
At the record, at Council Record 308, while vehicle number 3, authorized highway tow truck, parentheses, was stopped in front of vehicle number 2 to render assistance.
Yes, Your Honor, but it was later determined that that tow truck was unauthorized because it was not called by the NYPD. So the tow truck may have been authorized because it had proper licenses, right? It had insurance, but it wasn't the procedure of having the NYPD call this tow truck to come to the scene of the accident was not completed.
My colleague earlier said, what does that have to do with the accident?
Well, the tow truck was,
Right.
it had an improper, excuse me?
That's good. No, no.
The
go
tow
ahead.
truck was improperly parked. It was improper lighting, and it's our position that this was the proximate cause of my deceased client's husband's accident. In addition to the fact that the Gimenez vehicle was stopped on the Cross Bronx Expressway for at least 15 minutes.
Thank you.
Your Honor,
No, your time's up, so you
okay.
have time for rebuttal. Thank you.
Good afternoon. May it please the court, my name is Dana Beretta. I represent the first named defendant, Juan Javier Gimenez. Your Honors, I am fully cognizant of this court's time. Unless you have questions for me, I rely on my brief and I waive the remainder of my time.
No, we
I
have,
do have a question,
we
Counsel.
have questions.
Yes.
Go ahead.
Yes. Was your client's vehicle, was lights activated?
I represent the minivan, not the tow truck. His vehicle had become completely inoperable. The engine was off and it was
No, the minivan. Did he have I didn't see anything that said that the flashers were active.
No, he couldn't activate the lights. He had engine malfunctions and it was completely inoperable. The lights, it was completely dark. There were no lights.
Why isn't it? Go
The
ahead.
engine malfunction affected the lights?
Yeah, it was completely off. There were no lights on. The only illumination was from the co-defendant's tow truck.
Just to follow up on that, because I know that there was reference in your adversary's papers that he could have pulled over to the other side, but did he say in his affidavit that his vehicle was completely malfunctioning and he couldn't move
Yes,
it?
it was completely inoperable. He pulled it over to the far left, as close to the median as possible.
Is there a shoulder available?
No, there's not. Well, there's a shoulder, but it's only a few feet. It's not
Not
a
full
designated
shoulder.
lane. Yeah, it wouldn't fit the whole width of his minivan.
Whether there was a shoulder or not, I guess your allegation is that the car was not operable, couldn't be moved.
Correct. It was inoperable, could not be moved. It was stopped for about 15 minutes when the rear end
And it was
closed.
stopped in the left lane, which is the fast lane, correct?
As far to the left, yes.
And Counsel, as far as your client's statement in his affidavit, Mr. Chavez Gimenez said that there was no contact whatsoever between his vehicle and the Paulino vehicle. Is that borne out by the photographs that are attached as exhibits? Or is there damage shown to the minivan?
It is our position that that damage pre-existed the accident. It was an old minivan that he used as a utility vehicle, and that there was no contact between the plaintiff's car and Mr. Javier Gimenez's vehicle.
Does Mr. Chavez Gimenez say that in his affidavit? Because I don't see that.
No, he just says that there was no contact.
Does his affidavit address whether he tried to turn any lights on or put a flare up or put something around his vehicle to warn others about the car being in the fastest lane of traffic and stop? That he took all possible efforts. Does his affidavit address that?
Again, the affidavit does not address that. He did not.
Wasn't he, to make a prima facie case, doesn't he have a responsibility to show that he did everything in his power to make the situation as safe as possible by doing everything within his power to warn other drivers?
Yes, but considering there was an emergency circumstance, he
Right,
acted.
so he had to stop, but the question is what more he could have done once he stopped to warn other drivers, and whether he did or did not do everything he could possibly do.
He did not have flares in his vehicle. It was completely inoperable. He
Does
could
he
not.
talk about that as an affidavit?
He does not. But this is, Your Honor, this
Does he
is a
talk
clear.
in his affidavit about whether there was anything in his car he could have used to warn other drivers?
The law, that just requires us to demonstrate that this is a classic rear-end collision with a stationary vehicle. And whether or not there was contact between the plaintiff appellant's vehicle and my client, or the contact was solely between the plaintiff's appellant vehicle and the co-defendants is irrelevant, because at the end of the day, you have two stationary vehicles that could have been contacted, and the law.
But counsel, when we look at rear-end collisions, typically those cars are moving. Here you have a vehicle that's stationary for more than 15 minutes, right?
Correct.
So that's why you're being asked what what steps were taken to reasonably safeguard others of the hazard that was posed by the obstruction.
His lights could not go on, and he did not maintain flare.
Does he address whether he could have moved over to the right lane of traffic? Whether that was possible? Does he address that in his affidavit?
Well, the incident happened on the highway.
No, I understand that, but does he address in his affidavit whether he could have possibly moved over to the right lane of traffic as opposed to coming to a complete stop in the fastest left lane of traffic?
The vehicle was inoperable. Once it shut down, it shut down. He moved,
Does he talk about that in his affidavit?
He talks about it being inoperable and him moving it as far to the left as he was able to.
Okay, thank you.
Counsel, the term inoperable is not used.
Okay.
Thank you.
English is his second
Thank you.
language.
Thank you.
Thank you.
Good afternoon. May it please the court. I'm Richard Ashnault, and I'm here for respondents Taurus and Autorama. There were questions about the. Well, first of all, let me just address the issue with these photographs that we're talking about.
Can you just address the issue, because plaintiff started out their argument with the issue of 911 you weren't responding to a 911 phone call rather to NYPD, which is the only way that you're able to pick up or stop for disabled vehicles on the highway.
That's not exactly true, and the provision that is cited does not state that. And secondly, even if that were the case, this accident did not occur because the NYPD did not call my client in order to get this car off the highway. It didn't have anything to do with whether the NYPD called them or not. The fact is, there was an emergency on the highway. There was an emergency vehicle that was stopped there with all the lights fully on.
What about the argument that there's a dispute about whether those lights were adequate under the circumstances and typical tow truck lights?
I mean, they are typical tow truck lights, and they're the tow truck lights that are used all the time on.
You're saying there's no basis for their argument, it's unsubstantiated.
Exactly correct. And the photographs that they're referring to are not only not a part of the record here, they were never authenticated. They're not part of.
They were in NYSIF though, right?
I'm sorry?
The photographs, they were part of the e-file NYSIF documents?
They are part of the NYSIF submissions in the court below, but they were never authenticated. They're still hearsay documents. Nobody authenticated them after the fact. They're part of a report. That entire report was actually not authenticated. The police report itself is a hearsay document that was never authenticated. The police.
One of those photographs shows the tow truck with the lights on. You're saying
sorry?
that one of those photographs shows the tow truck with lights on. You're saying we should ignore that?
I'm not saying you should. I'm saying the court below properly ignored it because it's a hearsay document, and it's after the accident. It shows one light, only one light on, and it's a still photograph. So it doesn't really make any difference what the photograph is going to show in that one instant of time that occurred after the accident, according to the testimony of Mr. Torres, who was operating the vehicle. The dome lights were on before the accident occurred, and in fact, all the lights were on the.
If a triable issue of fact exists as to whether the tow truck was authorized or licensed to salvage vehicles off that highway, would that warrant or dictate the denial of your motion?
The denial of our motion? No, I don't believe it does. I think the question is immaterial because it's not a material question of fact because the accident did not occur, again, because of the authority or lack of authority or call of the NYPD in order to get our client there.
Thank you.
Thank you.
Your Honor, very briefly. The question as to whether the tow truck was authorized or not unauthorized goes straight to the gist of this case, and it's the fact that because it was unauthorized, it had improper lighting, improper procedures, and somebody's life was lost because of it.
Those are two separate things, right? It could have been unauthorized and have proper lighting. It could have been authorized and not have proper lighting. Either which way, I'm not sure how they relate to each other.
They relate because the regulation requires that there be a certain standard for the tow trucks, and it's our position that the tow truck didn't have the right standard, didn't have the proper
Do you have
lighting.
any evidence to support that other than an allegation?
No, Your Honor. We were in the process of discovery. I want to point out to the court that there were prior stipulations where the defendants agreed, and it was so ordered that they were going to produce their clients for depositions. The court, 1 month prior to making a decision on these motions, did also order the deposition of the defendants because discovery was necessary. So it's my position that the summary judgments were premature, and it shouldn't have been granted. There's just too much evidence.
Thank you. Thank you. CLSA Americas versus Mayo.
Good afternoon, Your Honors. Peter Bemke on behalf of the appellant. Your Honors, in a manifest disregard analysis, the court reviewing an arbitration award is required to undertake 3 inquiries, and Supreme Court in this case did not undertake any of them. I'm going to focus on what I think is the most important of the 3, which is that the reviewing court is required to determine if there is a legally correct justification for the award in light of controlling law. And
Was this award detailed in such a manner that it would allow such a review?
The award is not reasoned, but there's very clear precedent from the Second Circuit, and this is a federal law analysis, that when the award is not reasoned, even though the inquiry is made more difficult by that fact, the reviewing court is still required to review the record of the arbitration and conduct these 3 inquiries, including by making a determination as to whether there is some plausible basis for the award in light of controlling law.
Counsel, looking at the cases under the FAA, which I know is what your argument applies about manifest disregard, it's almost an impossible standard to meet. It's not just enough that there was an error in law. They have to have known of the law and, basically not followed it. And without having any decision, how can we possibly come to the conclusion that they knew about that case and decided to disregard it despite knowing that it was arguably applicable?
I suppose to handle the questions in reverse, Your Honor. So first, were the arbitrators aware of the controlling law? The controlling law here is that an employee's entitlement to a bonus is governed by the terms of the employer's bonus plan. That is from the New York Court of Appeals, the Hall v. UPS case cited in our brief. That is a principle that has been applied by this court on multiple occasions, including in Chapen and numerous other.
How do we know that they intentionally disregarded that law?
So I think if we look at what the employee handbook has to say, there's no question that they were aware of that.
The employee handbook says that the bonuses were discretionary, so why couldn't that be a way that the arbitrator rationalized it?
The plan had a number of things to say. Bonuses are discretionary. What that means under Kaplan and the other cases that we cited is that there is no legal entitlement to a bonus.
But I'm getting a little confused here because what you have to show is that they disregarded the law. You're talking about the factual basis as to how the law should be applied. The employee handbook is not a law. It's the facts underpinning the decision that's made. But you have to show that they knew about the law, meaning like Kaplan or the cases, and decided not to follow it. So pointing to the employee handbook is never going to answer the question of whether they did or did not know about the applicable legal standard and decided to disregard it.
I disagree with that characterization as a question of fact, because under the Wien and Malkin case, New York Court of Appeals, it explains that manifest disregard can be found if the award is flatly inconsistent with the terms of a governing legal instrument such as a contract. In this case, the document that governs the rights and obligations of the parties with respect to a bonus is the employee handbook.
Why couldn't they have decided, putting aside the legal error, why couldn't they have actually been thinking in their minds that none of those doctrines are applicable in this case? Because this was an unusual situation where there was a tremendous amount of alleged communication between the parties, that despite what the handbook said, that there would be a bonus in this case, and that the parties agreed that there was going to be a bonus. And why couldn't that have been a factual determination that that panel made, which we wouldn't know because we don't have a reasoned decision?
Again, it's a legal question, Your Honor, because the handbook, in addition to saying that bonuses are discretionary, it also states that no one is authorized to make a promise or representation concerning a bonus, that any such representations are not valid and unenforceable, and the company will not be bound in the absence of a written agreement.
Thank you. You have time.
Counsel, sorry. I was going to ask, aren't you asking us to speculate as to the reasoning behind the arbitration award?
It's not a question of speculation. When an award is not reasoned, it's the job of the reviewing court.
But it was your client's choice not to have a reasoned award, right?
Under FINRA rules,
both parties had to ask for a reasoned award in order to get one, right?
That is correct, Judge. And what happened at the time is that counsel for respondent did not want to request a reasoned award, so we also did not, because under the rules, there's no purpose in doing
But
so.
that's called waiver, right? That's called waiver?
Sorry, is it a waiver?
Kind of a waiver of a reasoned explanation. You have to ask for one, you don't, then you waive one.
We are not here to complain about the fact that the award was not reasoned. All that does in the manifest disregard analysis is it puts you into a different framework, meaning the court. Thank you, Judge.
Thank you.
May it please the court, I'm Evan Beloso with McDermott, Will & Emery. I'm representing the respondent.
Why wasn't there manifest disregard in this case? Because there does seem to be some pretty established precedent having to do with bonuses and enforcing the provisions of employee handbooks. Why wasn't it manifest disregard what the arbitration
Well, Your Honor, so as you yourself stated, manifest disregard is almost impossible. And that means for this purpose, there only needs to be a barely colorable decision. Now, we don't believe
What's the barely colorable basis for this decision?
Sure, Your Honor. So we have to delve into the facts here, which are the facts that were presented to the panel. There is a handbook in this case. The handbook was drafted by CLSA Americas. It is defined as, the company in the handbook is defined as CLSA Americas LLC. CLSA Americas LLC is a subsidiary of a foreign entity, CLSA BV, which is a Hong Kong-based entity. The individual with whom Michael Mayo, my client, spoke about bonuses year after year and who had the authority to determine that a bonus would be paid outside of the CLSA America structure was Lori Young, the global head of HR for the foreign parent company.
You're saying an argument, they could have decided this issue on it not being a bonus being given by the company that provided the employee handbook.
The bonus was given by the company, but the discretion to allocate it was not made by the senior management of the company. And we know that from the prior course of dealing. Every year, Mr. Mayo spoke not with his boss, the CEO, Rick Gould, or with the head of HR in the Americas, Greg Reber. He spoke only with Lori Young, the global head of HR, and Edmund Bradley, the global head of research. The year prior, just 1 year prior to this bonus that we're talking about here, Mr. Mayo was allocated a very small relative to his compensation.
So then the part of the employee handbook that indicates that no one is authorized to, on behalf of CLSA Americas, to make any promise or bonus unless it's done by written agreement signed by an authorized representative wasn't followed.
Well, we don't believe the language of managers or other senior management are not authorized to make any representations necessarily applies here. CLSA Americas drafted this. It's completely unclear if they're referring only to folks who work at CLSA Americas or if it somehow binds folks who don't, who come in and say, we're going to allocate bonuses outside of the framework.
Your client was employed by CLSA America, correct?
He was employed by CLSA America.
You're saying that because he was having these bonus discussions with the, excuse me if I get the title wrong, the head of HR of the parent company, that this doesn't apply.
All the decisions as to his bonus were made outside of CLSA Americas. The year prior.
Whose behalf?
Certainly on behalf of CLSA BV, the parent company, CLSA Americas, the CEO testified, I have no control over discretionary bonuses at all. It's solely done by Hong Kong. The year prior, Hong Kong allocated a much smaller bonus to Mr. Mayo.
How much was that bonus?
That bonus was $100,000. He called Lori Young. Again, they had these conversations, and Lori Young found an additional $1.9 million to pay him. He called it a retention bonus. It wasn't part of the handbook. It wasn't part of the normal bonus pool. It was simply paid, and there's testimony from the CEO of the Americas who said, I don't know where he found that money. He came up with it.
So what's the barely colorable justification for the amount of the award, the $400,000?
Well, the panel didn't have a reason to award. Certainly, Mr. Mayo was seeking a much larger award.
He was seeking $3 million, right?
He was seeking $3 million.
400,000 is a far cry from $3 million.
It is a far cry from $3 million. That is the decision of the panel based on whatever evidence they heard.
And that's precisely the problem, that we don't know what it is, right? Without a reason to award, we just don't know what they were thinking. We don't know anything.
We don't know what they were thinking, Your Honor. That's exactly right.
So is it the rule that when you don't have a reason to award, that manifest disregard just doesn't apply?
I would love to say that that's yes, and it doesn't. The truth is, it can. It's just even harder. And again, the standard is an egregious impropriety, which is a barely colorable justification involving willfulness. The arbitrators, by reviewing nothing, the arbitrators essentially, or a reviewing court has to essentially say, you must have decided to willfully flout the law and say, I don't care that that's governing, I know it's governing, and I'm simply going to ignore it. Mr. Mayo put in testimony, he testified. He put in case law about implied contracts. He put in case law about prior course of dealing. And he argued that this Kaplan line of case doesn't apply to him here. It doesn't apply for a variety of reasons that he's articulated. Mr. Young wasn't an employee. There was a long course of dealing that is not present in Kaplan or its progeny. There's ample reason why an arbitrator, a panel could have looked at this and said, I get the rule. It's the general rule. If this was done by Rick Gould, the CEO of the Americas, maybe I'd agree with you. But they did it just last year. They had a totally different way of paying you last year. Obviously, he had apparent authority. I understand your argument. So that's the standard that the panel had to go with without a reasoned award, which again, they didn't ask for. Their argument really boils down to no matter what the arbitrator decided, if it wasn't zero, we can't lose. It has to be wrong. That can't be what happens here. The arbitration panel heard testimony from multiple people. They heard expert testimony. They reviewed hundreds of pages of
In terms of the reason to award, either party could have asked for one, correct? It's not, or is it that both parties had to ask for it?
I believe both parties had to
If one
ask and
party
agree.
objected, no reason to award.
I believe that's the case, and I know FINRA can if the arbitrators just want to place a.
Can we ask for one?
Maybe it's been a long time, but I noticed my
Thank
time
you.
is out, so thank you.
Your Honors, I heard a question from the bench, which I think actually gets to the heart of this, which is CLSA BV, which is the parent company in Hong Kong the counsel alluded to, is not the party that was sued here. They're not the party that was being ordered to pay a bonus under the award. The company is CLSA Americas. We know what the handbook has to say, which is that no one is authorized to make a promise of a bonus. Any representation from senior management, which Mr. Mayo testified he understood to mean Lori Young, the executive that was mentioned in counsel's argument.
Counsel, what do you say to the adversary's argument that the handbook applies only to CLSA America?
I agree with that, Judge. And this
And
case
just to
is
follow
about
up
whether
on that, the
CLSA
bonus-
America should pay a bonus.
The bonus didn't come from CSA America. From what I'm understanding, it came from the Hong Kong office.
I believe what counsel is referring to is that Mr. Mayo had conversations with senior executives at the parent company level. He would discuss his bonus, and the Supreme Court found that there was inferred that there was an agreement reached, an oral agreement reached with that executive as to whether CLSA Americas should pay the bonus. And what the CLSA Americas policy states is that no one has the authority to enter that agreement on its behalf. That is the key here. And what I think is very telling from both the papers submitted on this case and from counsel's argument is that no one has put forward a plausible justification as to how that oral agreement could be enforced against CLSA Americas, given that clear
What about
language
his
of the
argument that if it's true, there's no way they could have won this arbitration under your argument, that no matter what happened at that arbitration, you were going to have a valid argument about manifest disregard?
I agree with that, Judge. And frankly, if this were brought in court, it would have been dismissed at the pleading stage, and the case would have been over at that point, because the law is absolutely explicit on this point, as is the handbook.
Isn't that one of the inherent dangers of opting for arbitration?
It is, and the protection against that danger is that there is a manifest disregard analysis that can be conducted, which the Supreme Court did not do in this case.
Thank you.
Thank you, Judge.
Moyes versus Chapen School?
Honorable Justices, may it please the Court, my name is Dennis Monaco. I'm for the defendant appellant, Chapen School. This is an appeal from a use of monkey bars by an 18-year-old student at the Chapen School. At the time, they had taken a sole survivor's photograph.
Well, wait a minute. When you say it's about the use of monkey bars by an 18-year-old, she was standing underneath it, right?
She was standing underneath.
He wasn't on the monkey bars.
She was using the monkey bars for a photo with her friends. There were 11 other students present. She was
There were
standing
about
underneath.
9 other students that were on the monkey bars, and she was standing underneath when the monkey bars collapsed.
Correct. And this was in the Carl Schurz.
When you say that she was using these monkey bars for a photo shoot with her friends, I mean, that's not necessarily true, right? Because we have this affidavit from Kathleen Parker on behalf of the school that alludes to the fact that this was a school-sanctioned photo shoot. Like, they provided uniforms, they provided cameras,
So the school
there was a
section-
yearbook staff.
So the school section portion of the shoot was done on the school steps, which was testified to as by the plaintiff. They took the photo with the photographer from the school on the front
What
steps.
about all the past years where the yearbooks show this photo, that this was a yearly tradition? Every year, the students went to the monkey bars and took this photo. This wasn't a surprise that this was happening this year, and it never happened before.
Well, they went to the park. They didn't necessarily go to the monkey.
But there are many other photos of years past where that group, the sole survivors, were on the monkey bars for the same picture.
I haven't seen any other photos other than this one in the yearbook where there's photos of them actually on monkey bars. The main photo was
Counsel?
taken. Yes. Sorry.
You alluded to, it's okay. You alluded to the age of the plaintiff who had turned 18. So there were 12 students involved in this photo, 6 on the bottom underneath. The plaintiff was underneath the monkey bars and 6 students on top. If I remember correctly, the 8 of those students were 18 years of age or older, which would mean 4 students were minors. What do you have to say with respect to the minors who participated in the photo? By definition, some of them had to be on top, right?
So I'm not sure of the age breakdown, but in respect to them being minors, the case that's really on point is the Charles versus City of Yonkers case, where the decision decided that there are no regulations really in the state of New York for the use of monkey bars. And this case applied to a 4-year-old who was at school recess on school property, on school equipment when he fell from the monkey bars, and that case was dismissed. This is a case in a city park across the street after plaintiff had signed herself out of school to go take these photos with her friends. And in turn, with respect to the minors, I think that's where that comes in. In the Charles decision, they determined that there is no proper age for the instruction and use of monkey bars, and you would assume that someone who's 18, it doesn't require the supervision of the school to know that you shouldn't stand under monkey bars when someone else is using them, and the proper use of monkey bars. You could see in the photos, the monkey bars are only inches above the plaintiff's head. If she went to use these herself the proper way, she wouldn't have been able to. And, you know, so it's my position. You want me to stop or?
No, I mean, you have 30 more seconds. I
Okay,
thought you were
sorry.
wrapping it up the way you were speaking, but
Okay.
you can use your 20 more seconds.
So, I mean, that's really my position, is that it's an 18-year-old student who was going away to college literally in 3 months, who didn't
But
need
as Justice
proper instruction.
Rodriguez mentioned earlier, and I think you're certainly going to ask your friend for the plaintiff, their allegations are largely focused on the failure to adequately supervise the other students, not just the plaintiff herself, but the other students who, along with the plaintiff and the apparatus, formed this unfortunate perfect storm for this accident. So the plaintiff is 18 and I think was going to Cornell. She's a very smart young woman, but there were other people involved with this who may not have been of legal age, who were students at the school that are part of their allegations of negligence. The school failed to supervise them as well.
Initially, I don't think that's actually in their pleadings, that the other students were failed to be supervised. It was that the plaintiff was failed to be supervised. And in addition, into the age, I think that the important factor is this is a playground designed for 5 to 12-year-olds. It says it right there, Catbird Playground. I believe there's a photo of the plaque. And the city testified.
But there's
that
two
it's the
sections,
misuse.
council, aren't there? Aren't there two sections at Schurz Park? One for smaller children and one for older children?
Exactly, and this was in the city.
And weren't they in the section for the older children?
They were in the Catbird area, according to the city's witnesses' testimony, and the accident occurred from the misuse of the monkey bars.
Thank you. Thank you very much.
Thank you.
Good afternoon. Elizabeth Islander for the plaintiff respondent, Chanel Moyes. With respect to the age, that is a red herring. Ms. Moyes was a senior in high school. She was 18. While technically accurate, it's willfully misleading. She was a student at the school and entitled to be supervised by the staff at Chapen.
Well, I mean, this didn't happen on the school property, and your adversary points out that the official photo was taken on the steps. Was it taken someplace else?
Your Honor, that is misleading and inaccurate. The record shows that this was a yearbook event, and in fact, if we look at page 1133, which is an email from the head of the upper school, he calls it the annual yearbook event. It was a school-sponsored outing to the park.
There really is no opposition from the school that this is a tradition. Right?
Not necessarily, Your Honor, but they are trying to create a distance from the fact that whether or not it was sanctioned by the school. The school provided the uniforms for I'm going to call them girls.
Just to follow up on my colleague's question, your adversary also indicates that the plaintiff has signed herself out of school.
Oh, let's talk about the record and what it talks about with signing out, Your Honor. The plaintiff testified, and she also put in an affidavit in this case, that the signing out was really almost a ministerial purpose to make sure that the school would know who was there in the event of a fire drill.
And in fact, they were required to return to the school.
That's right, Your Honor. It was during the school day. And in fact, the deposition of the director of security, Mr. O'Day, who is the only witness that Chapen put up in this case for a deposition, testified, and that is on page 545 of the record. He says the sign-out procedure was so they would know who was in the school in the event of a fire or, unfortunately, under the circumstances these days, an active shooter. It wasn't a release of the school from any type of supervisory responsibility. So it was a school-sanctioned school event, and therefore,
Counsel?
Yes, Your Honor.
Counsel, I am looking at record page 1133, and that is the email from the head of the school, Mr. Malloy, head of the upper school, to the parents, informing them about an incident that occurred this afternoon in Schurz Park. Class 12 students who have been at Chapen since kindergarten take a photograph every year for the yearbook. These sole survivors wear their lower school uniforms and pose for a picture in the playground of Schurz Park. Is that what you were referring to before?
Yes, Your Honor, it is. So
there is no issue but that this is a school event.
Yes, but for some reason, Chapen seems to be trying to dispute that, Your Honor. And they refer to what I call inadmissible hearsay emails, which are random emails that were never authenticated by anybody, that are relied upon by Ms. Parker, who put in an affidavit for Chapen, who apparently was the school nurse, who she's not even on these emails. They talk about Facebook, they talk about Instagram. Again, the record is bristling with issues of fact with respect to what it is the students were doing in the park. And as Judge Rodriguez pointed out, the plaintiff is claiming that not only was plaintiff not supervised on the playground, but the other students were. Moreover, there's nothing in the record to provide the age of every single kid who was in the park that day. No, also missing from the record that Chapen did not put in their motion is an affidavit or a deposition or anything from the yearbook faculty advisor. Where's that information? Where is that testimony? What about witness statements from each of the kids that were there to talk about how old they were or where they're going to college? In Chapen's brief, they talk about these kids are adult students. They kept saying adult students, which is an interesting turn of phrase for anybody who's had a teenager, but and that they're all on their way to Ivy League colleges. What's that got to do with anything? And again, not in the record. It's just more language by Chapen to keep repeating these things that are just simply not in the record. What's also not in the record, and this is very important, because it has to do with the signage, and I think Your Honor was asking about signage with respect to the big kid part of the park or the small kid part of the park. Chapen had permitted and encouraged their kids to go every day for over a decade to go to this park. There are no signs in the park giving a weight limit or an age limit on the catbird monkey bars, which were involved in this photograph. And in fact, the director of security, who again has been working for Chapen for 12 years, he talks about on page 531 and 532 of the record, no signs. We specifically asked him, are there any signs giving a weight limit, an age limit for use of these monkey bars? He said no. Moreover, the city witness, Ms. Dorothy Rowan, who was a supervisor for Carl Schurz Park, she also testified. And her deposition starts on page 449 of the record, and that testimony is on 470. She conveniently says, I don't recall. She was confronted with a number of records showing how dilapidated and how rusted out and dangerous these monkey bars were, because once they collapsed, we could see, and Mr. O'Shea, the director of security, took like 30 photos, which are in the record, showing how rusted out and also how it was planned that they were going to replace the monkey bars. But Chapen did nothing to ascertain the safety and whether or not the playground was reasonably safe. Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court. Martin Rowe for Respondent City. I would echo my colleagues' points that taking the record as a whole, we have a student who is provided with a different school uniform than she normally wears from the school. The school gives another student a camera and releases these students to take a picture that the school includes in the yearbook every year at this same playground. And the plaintiff herself actually affirmed in her affirmation that this was not for the purpose of Facebook or looking cute on Instagram. The purpose of being there was to take a picture for sole survivors to be in the school's yearbook. And as my colleague pointed out, the email from the headmaster of the school, Mr. Malloy, the day after the accident, it really is dispositive here in that the headmaster admitted that this was a school function. Every year they go do this. So to turn around and say, no, they were off campus, this isn't our responsibility. It's just flatly incorrect as a matter of fact. And I think it bears pointing out as well that the students were required to go back to school. Regardless of whether this accident happened or not, they have to go back to school before the end of the day. So they're not completely left to their own devices. They have to go back to school, and the school had them sign out so they were aware that they're not there. And I think taking into account the posture of where this case was, it was a summary judgment motion. And it's simply a matter that is replete with issues of fact and issues of credibility. We have witnesses on one side saying, I was never told anything, they just let us go. And then we have the witnesses, the plaintiff herself saying, we did this every year, this is what we did, we went there to take this picture for the yearbook. So that alone, I believe, represents an issue that has to go to the jury, as does the issue of proximate cause here. It was Chapen's burden to demonstrate that they bore no comparative fault here. And as I pointed out, they released these students into this atmosphere, and they are still responsible for the outcome of releasing those students.
Thank you.
Thank you.
If I may, Your Honor. So page 254, plaintiff cites that she knew she signed herself out of the school and that no one was going to be with her at the playground. And she also testified around the same page number that there will also be no one directing or supervising from Chapen the photographs taken in this park. Let's again, just remember the point is, this is a student who left the orbit of the school. This is for a school book photo, whether or not it was for Instagram or even for the school. She knowingly left the school
Well, I
without
don't know if
supervision.
but that does matter, though, if it is for the school yearbook, and that's been the tradition of the school to include it in the yearbook. I mean, how are we supposed to view that has nothing to do with the school?
Well, she knew that she was leaving with no supervision from the Chapen school. That's in her testimony at around record 254. She then is on public.
All the other students were
playground.
leaving without supervision as well, right?
Correct.
So can a student, whether 18 or under, prior to graduating high school, can a student waive, the student themselves, not a parent, can the student waive the right to adequate supervision?
When you sign yourself out of school, generally, I mean, at 18 years old, that is what you're doing, especially when you testify that you know that there's no one there to supervise you at the park. And we are talking about monkey bars in a public park, not Chapen's own apparatus that failed.
Thank you, although they use, anyway, they use it regularly. Thank you. Rational Special Situations versus Bank of New York Mellon.
Good afternoon, Your Honors. May it please the court, Pat Rocco on behalf of Plaintiff Appellant Rational Special Situations Income Fund. As Your Honors are aware, my client, the plaintiff, holds UCF certificates that were issued back in 2005 and 2006 in an original offering. They're called Class 1A notes. He's the successor to those notes.
Let me ask you about the heart of it, and I hope I get the words right, because it's factually complicated, although I don't think it's legally complicated, this case. But the issue is how the funds in the collection accounts are to be distributed. Why isn't that issued governed by the collection amount agreements rather than by any provisions of the standard terms? Because the collection amount agreements have very specific provisions how these funds are to be distributed, whereas the standard terms do not. So why isn't that the controlling document? And what? Well, let me just have.
They both control, Your Honor, but my client was not a party to the.
Right, but there's no argument that they did not follow the distribution as specified by the collection amount agreements, which really have nothing to do with what ultimately ends up. It's a waterfall provision, so it's only what's left over that ultimately goes in, but it doesn't govern what the two different funds in the fund get ultimately. It governs 2 steps back.
Well, let me back up. 2 things. The Class 1A notes were only ever liable for $1.2 million of insurance reimbursements. That was made clear in the indentures.
Right, but that's not focusing on the specific issue, which is that what governs the distribution of these funds? And you seem to be arguing about provisions in the standard provisions, 301 and 302, where it seems that there are very clear provisions in the collection amount agreements that govern the distribution. It has nothing to do with how it ultimately gets distributed in the Voyager Fund.
Well, I think they're interrelated, Your Honor, and if you look at the.
So how did they not follow what they were supposed to follow in the collection amount agreement?
Well, the collection, so 2 things. First and foremost, the standard terms do require Bank of New York as trustee to allocate, and that's in 3.2.
But the standard terms talk about withdrawals and distributions once the money comes into the Voyager accounts. But these funds only come into the Voyager accounts once they're distributed initially by the collection amount agreement. So
that's not correct, Your Honor.
Why is that not correct?
Because the collection accounts, according to the structure of both the standard terms and the collection account agreement itself, is where everything has to be put first. And we argue in 3.01.
Right, that is where everything has to be put first, and that it has to go through the waterfall provisions of that agreement before it even has any chance of coming into.
And then just to follow up on that, I would point to, and maybe you can clarify, section 3.02A, which says basically what my colleague is saying, right? It comes, whatever is going on in the collection account, then it gets deposited and then distributed later on in 30.02C.
So the collection account agreement, though, clearly says, and there's no debate about this, it says that the trustee has to report the reimbursement amounts by a class basis, so that the Class 1A notes and the Class 2A notes.
You keep saying that, but I'm looking at the language of 301 and 302, and they talk about withdrawals. They don't say anything and do not require BNY to deposit money from the collection amount into the CDAs. So,
Well, first and
no,
foremost.
what is the language, the specific language you're referring to? Let's start with 301B that supports your argument that has anything to do with how those amounts are distributed, or how BNY is required to distribute those amounts.
Because you have to read it in total, Your Honor, and 3.021 talks about reimbursement amounts, and it says that the underlying RMB trustee to the collection account maintained by the collection agent shall allocate such amounts based on information provided to it by the underlying RMBS trustee. And we know that's a reference to the collection account. The collection account says—
Right, but the collection account agreements have very specific provisions in the collection agreements how those funds are to be distributed, and they have nothing to do, those provisions, with how the way the funds are going to be distributed in the trust.
But the reality is, Your Honor, that they violated the collection account agreements. We allege that in the complaint. And so the standard terms tell you have to allocate according to the reports the trustee has to issue. The collection account agreement says unequivocally that those reports have to be on a class basis, class by class basis. So the amount
Class
owed—
by class, isn't that a reference to distribution, not what has to be deposited in the account?
It's a reference to how much has to be given to Syncora. It has to be on a class basis. They can't—
Distribution.
Yes, Your Honor.
But that doesn't mean that something has to be deposited. In other words, after paying what they need to pay to CGI, there could be nothing left over.
I know, but they paid money that SGI, I'm sorry, Your Honor, wasn't entitled to. The collection account agreement says you have to pay the reimbursement amounts on a class basis. And the class basis is a clear reference to the fact that Class 1A notes were only ever liable for $1.2 million, and the Class 2A notes, who were totally separate junk bond-like notes that people didn't have to pay a premium for, those notes were liable for $144 million. And they say because the collection account has an aggregate amount of debt in it, you have to ignore the plain meaning of the class-based description in the collection account. It says you must report on a class basis and you must allocate.
And sir, what specific provision supports the argument you just made about making that distinction based on the class?
That would be collection account agreement at record 570, section 3. It says, based on information received, set forth in the underlying RMB reimbursement amount on a class basis, the collection agent shall allocate such classes underlying RMB reimbursement amounts to SGI, such classes underlying reimbursement amount. The only class liability that my client had, being a successor to the Class 1A notes, was the $1.2 million. And that's what the indenture said and what the offering memorandum said.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honor. Chris Haupt of Mayor Brown for Respondent BNY. I think there are kind of two ways or two possible issues to look at. One is whether they have stated a claim in their complaint when they tell us this is the section of this contract that you breached. Have they actually stated a claim? A separate question is, might they have another claim under another contract that they have, for whatever reason, chosen not to plead? We argued—
How do you respond specifically to their argument about the class-by-class distribution?
Oh, sure. So I just happen to have a copy of the other collection account agreement in front of me. So it's record page 584, but it's very similar language to what counsel just quoted. So in paragraph 3 of the collection account agreement, okay, again, this is not the contract they say we breached. Paragraph 3 says—
You're saying you breached the standard terms.
Exactly. And so Justice Maisley, I'll come back in a second, but Justice Maisley said, I looked at those two sections of the standard terms. They don't say anything about the allegations in the complaint, so I don't need to reach the hypothetical claim under the collection account agreement, but I'm happy to go through this. The opening paragraph says that the collection agent will allocate reimbursements that come in from the RMBS trust. Now, first of all, the reimbursements under the RMBS indenture are not owed to the note holders, as counsel seems to be implying. They're owed to Syncora. If you just look at the indenture, all of that money goes to Syncora. It's only because of the collection account agreement that any of that amount could ever go.
Just as if there's anything left over after Syncora is paid, then it could go into the trust.
That's exactly right. So
And the purpose of that agreement was to make sure that Syncora wasn't double dip, right? That they weren't paid twice.
Well, it was to make sure that they got repaid for the pre-2009, the pre-Voyager claim amounts that they had paid into the trust. And then they don't get repaid for post-2009 reimbursements that cycle back through
So
Voyager.
what's wrong with the argument that because of the way that the amounts were distributed in the collection agreements, it ended up violating their rights under the trust?
Yeah, so to go back to page 584, it says the collection agent allocates the reimbursements as follows. And there's A and B. So A is to SGI, that's Syncora. Then B says, any other amounts not allocated pursuant to paragraph 3A above to the post-closing holders, which are listed on a schedule, and those are various Voyager trusts. So you don't pay the Voyager trusts, you don't get to 3B unless you've fully paid all the amounts in 3A. What does 3A say? One is interest on the SGI claim amounts, which in the one I'm looking at says it's $76 million, and the one that he has it's $64 million. And then 2 is to repay the SGI claim amounts themselves, so interest and principal on those amounts.
So it seems that no matter which way you slice it, SGI is protected and maybe no one else is.
Well, SGI gets the money until they're repaid principal and interest on $76 million.
Is there any requirement that monies be left over to deposit into the Voyager trust?
No, I mean, it would be kind of unusual if the RMBS trusts had so much excess cash flow that they could fully reimburse Syncora for all of the insurance claims that it paid during the housing crisis. I mean, the reason you have insurance.
Why would anyone purchase this uninsured certificate?
Oh, well,
I mean, what are the odds that if you enforce it as written, that ever be, as you're saying it should be enforced, that there would ever be a payment?
Because
for the
what they're
uninsured
getting
certificate?
here, they started off with an RMBS certificate that was backed by some bad mortgages and by an insurer that was ultimately in financial distress. And they voluntarily exchanged that for the UCF certificate plus a pile of cash, a lump sum of
You're
cash.
saying they already knew they weren't going to get anything on the RMBS?
They made a business decision to accept, to hand in their old certificate and get an uninsured certificate along with a cash payment.
They weren't just a new buyer coming in and buying these certificates?
I mean, that's what they allege. They allege that they participated in the exchange offer. It was a voluntary offer. They could have kept their old certificates if they wanted. And they do continue to get, most importantly, principal and interest payments on the Class 1A notes. Those go direct, those don't go through the collection account. Those go directly to the Voyager Trust, and they're paid out to the UCF certificates. The reimbursements are a pretty small amount of the overall cash flow. So they still get principal and interest. They don't get the ongoing claim payments because those cycle back to Syncora. And then if there are enough reimbursements to pay Syncora the $76 million that's specified in the collection account agreement, then any further reimbursements would go to them. I could briefly address the class-by-class point, or I could not.
You could address it in a sentence or two.
The reason that it says to allocate the money class by class is in 3B, the post-closing holders are different Voyager trusts for each class. So that's why you have to run the waterfall
Class by
separate.
class is only referring to the different Voyager classes.
Well, it refers to the RMBS classes, but the reason that you have to segregate them in the waterfall is only relevant if you get to Part B. Both classes of reimbursement amounts run into the same $76 million in paragraph 3A. And so that's why, on the facts alleged in the complaint, we still haven't gotten to 3B, and we may never.
Thank you.
Thank you, Your Honor.
Good afternoon. Mark Goodman, Debevoise and Plimpton for Syncora. I'm not going to address unless the court asks me to.
Assume you have some of the same arguments. You would have some of the same.
I'm adopting everything this gentleman
Right,
just said, word for word, and I'm here really to address the unjust enrichment claim against Sincora. And let me just say to start that my friend here stood up and in response, Justice Kern, to your question, answered immediately, my client, quote, my client is not just a party to the collection accounts agreement, is not a party to the collection accounts agreements, but they are interrelated. We argue that they're interrelated in our papers. And of course, if you read their briefs and if you look at the argument below,
Contract claim. I mean,
they make a contract claim that includes the collection account agreements, notwithstanding the fact that they are not a party to those.
So if they're bringing a contract claim, they can't bring a quasi-contract claim against you because that's a very
exactly the
black-letter
point.
principle of law.
If you read their papers, Your Honor, the point they make is because the appellant is not a party to the collection account agreements, they say a quasi-contract claim is appropriate. But as Justice Pitt Burke pointed out, if you look at the operative agreement that they do make a claim on, the standard terms agreement, you will see that there are references there, including a defined term that refers to the collection accounts. All of these agreements, as counsel has pointed out, work together. And so I think it is undisputed by the parties, by any of the parties, that all of the issues here are governed by contract, all of them. Whether the appellant is or is not a party to the, directly a party to the collection account agreement is just not relevant. And if you look at all of the cases, and I mean quite literally all of the cases in New York, including all of the recent cases from the New York Court of Appeals, they all state the majority rule, the kind of default position, and that is that a plaintiff cannot recover for unjust enrichment while at the same time alleging existence of an express contract covering the, and this is important, the subject matter of the dispute.
And you're arguing there's no question that the whole subject matter of this dispute is the interrelated contracts.
Not only is that, not only, Your Honor, is that our argument for present purposes, but I think more importantly, the appellant has taken that position in the complaint, in oral argument before Justice Maisley, in its papers before this court. There's just no doubt about that.
Do you want to address the alternate argument you have that there's not a sufficient even if there was a viable claim, there's not a sufficient relationship to?
Well, in some ways, Your Honor, I'm doing this in the reverse order because I think the second argument is much easier, much more kind of straightforward and direct than the first.
You'd win on either argument. Either one independently would be a viable basis for dismissal.
Correct, Your Honor. But what I'm saying is that the second argument may be even easier and more straightforward. Justice Maisley found that the complaint does not, quote, indicate a relationship between the parties that could have caused, and this is the key, reliance or inducement, end quote. And those concepts of inducement and reliance are very important because all of the cases, again, all of the cases point out that there can only be an act of equitable injustice, which is what we're talking about here, between the two parties when they have a relationship that has been abused by one to take advantage of the other. Here, there is no relationship. If Your Honor looks at the papers and looks at the complaint, there was 1 week before the letter was sent to the bank giving rise to this dispute, my client received a telephone call from Mr. Rocco's client asking a question about how the restructuring had been done. Before that call, they had never met one another. There was no communication, no contact, none of the kind of interactions that would give rise to even a potential for inducement or reliance. So leaving aside our first argument, if Your Honors just focus on the second argument, there's no relationship here, none. Now, counsel's probably going to stand up and say, well, they were parties to an agreement or more than one agreement, and therefore there's a relationship. The case law is unambiguously clear that just because two parties happen to be joint parties to an agreement, that is not sufficient to give rise to the kind of relationship that the quantum merit cases would require. So if there are no other questions, thank you, Your Honor.
Thank you.
Since I only have a minute, Your Honors, I'm going to have to rely on my papers for most of the last argument there, except to say that the offering memorandum itself, Your Honors, talks about SGI and the fact that they're the former insurer and they're going to have rights to reimbursements that are going to come out of the pocket of my client and UCF certificate holders. So the relationship is baked into the very transactional document that sets up the notes. So I don't think there's any doubt that there's a sufficient relationship. But I want to go back to the collection account agreement because it seems to be a concern of Your Honors. This is a motion to dismiss. And we alleged that the reimbursements that went to pay SGI.
Right, but if we can interpret the agreements as a matter of law and the agreements are.
But they made a
ambiguous,
statement that's
the
contrary
basis
to the agreements.
Counsel, you didn't even let me answer the question.
They've they've contradicted.
You have to,
Oh,
you have to let me answer the question.
sorry.
Ask the question before you answer it.
I'm sorry.
You already started, so. But you should let the judge finish the question.
I apologize, Your Honor. So
ahead.
I'll answer your question.
Go ahead.
So they made the point, Your Honor, that there was no money that was meant for the UCF certificate holders in the collection account, and it was all due to be reimbursed to SGI. But the complaint says $18 million of those reimbursements were on the Class 1A notes that only had a $1.2
No, we understand
million
your argument. Thank you.
liability. Okay,
Thank you very
Your
much.
Honor.
Stewart versus Prospect Transportation.
Good afternoon, if it please the court. Renaud Bleeker of the law offices of Brian Rail for the appellant and plaintiff Eddie Stewart. Your Honor, we represent Eddie Stewart on the counterclaim. This is a very simple case. It involves a motor vehicle accident in the Bronx.
A little unusual, actually. We don't usually get allegations like this.
Well, yeah, I know. When I heard about the payment of $200 by the defendant, I was amazed. And I made sure to mention that in my papers. Basically, Eddie Stewart is driving Storabel Molino's Dodge minivan.
No, we're familiar. So why isn't there a credibility determination that needs to be made here? Because if we accept the defendant's allegations as true, then there was no accident.
Well, that's exactly the point. Frankly, I did not know that they were going to claim there was no accident whatsoever. But when that occurred, I put
And
him
they're
on.
also claiming that the passenger.
He wasn't there. Yes. And frankly, I adopted that. I said, look, Your Honor, now all you have to decide is whether Eddie Stewart caused injuries to his passengers. And their response is that there was no accident, there was no contact, and she wasn't even there. I said, well, then that means both versions, under both versions of the accident that are before the court, my driver, Eddie Stewart, did not injure his passenger. So the counterclaim has to be dismissed under either version of events. The problem here is the judge was entirely correct saying, I don't have to believe any one particular witness. However, he can't disregard both of them.
But what happens if they believe, or if the trier of facts believe that there was a passenger in the car, that maybe there was a hit, but it wasn't the way it was? I mean, there are many different permutations that the way it could eventually play out. And if there's any chance whatsoever that one of those could result in a contribution situation.
Right, but what that means is that the judge below, respectfully, I don't know the judge, he's a fine judge, but he was in error in this case. He's really inventing a third version. You know, and I'll give you a hypothetical. If in response to my motion, the defendant had said, look, what happened was my truck was there and then Eddie backed up. Let's say that the driver took the minivan and put it in reverse and backed up into my truck. That would establish some evidence of negligence against my driver, and I would agree. The motion has to be denied. It's completely an issue of credibility as to whether my driver's actions caused injuries to his passenger. That's not what they said. What they said is there was no contact and no Molina, no passenger whatsoever. And in that event...
Counsel?
Yeah.
So in looking at the photographs, it was interesting that Mr. Stewart's co-plaintiff, Miss Molina, is nowhere to be seen. She's not seen in the car, and she's not seen on the street, and she's not seen anywhere at all. What do you have to say about that?
Well, all I have to say about that is that when the photograph was taken, she's not in the photographs. I don't know where she was. but we're not conceding the point. My point, though, is if she was not at the scene of the accident, then my driver, Mr. Stewart, could not have injured her. Therefore, the counterclaim had to be dismissed under either version of events. And what Judge Barbado did, respectfully, is say, well, theoretically, there could be some scenario where he did injure her. However, there's no evidence of that. There's no evidence of it whatsoever. We feel that he was compelled to grant the motion and dismiss the counterclaim. And the fact that she may not have been there merely reinforces the fact that he couldn't have injured her then in that event.
But this was supposed to be his co-passenger, right?
That's correct. And they're both represented by the same attorney. And if there was any evidence that Eddie was 1% responsible, then the attorney could not be representing both of them. But in the,
You're saying under either version, there's no indemnification or contribution. That's your argument.
correct, Your Honor.
Okay, thank you.
Thank you.
Good afternoon, Your Honors. Luigi Tolis, Fixer and Lagatuda for respondents.
So what's your response to that? So I'm following his logic. He's saying if the court believes your client, then there's going to be no contribution or indemnification because there's going to be no liability. There was no passenger in the car and the accident never happened. If the court believes the plaintiff's version, then you're going to be held, your client's going to be held responsible because you rear-ended the vehicle. So, which is pretty established law. So under either scenario, he's arguing there's no basis for contribution or indemnification, which doesn't mean the case doesn't go forward. It doesn't mean you don't have a trial. It just means there's no viable cross-claim. So what's wrong with that argument?
To be fair, it's a false syllogism. And I should also point out that...
Why is it a false syllogism?
Because he's saying under either series of events. Our position is that A, no accident occurred, B,
Right, but
no,
if
she's
you
nowhere
win
to be
on
seen.
that, if you win on the no accident occurred, then there's no contribution or indemnification.
We're not trying to establish any sort of facts at this time. This motion was brought before any discovery, any depositions, any established
You're
facts.
saying a third version of the accident may come out after discovery.
Yes, and I'm saying the judge was not compelled to find any specific series of facts. It's not the judge's province to find his facts or my facts.
But you're saying that it's a real possibility that ultimately there may be a whole different version.
I have simply no idea what Ms. Molina is going to say because there was no affidavit by Ms. Molina.
Is your basic argument that this motion is premature?
Absolutely, the motion was wholly premature.
Is that your primary argument, that it's just premature to make a determination at this point?
Yes, it's wholly premature. The facts are in ready dispute. There was no abuse of discretion in failing to find any sort of specific facts as to this. Should the court have found that under any series of events, Ms. Molina, whether she was there or not, it extinguishes any counterclaims, I put forth that's a finding of fact. So, subject to any other further questions, I'll cede the rest of my time just so the court can hear whatever remaining.
Any questions?
Today.
Okay, thank you.
Thank you so much.
To briefly, I won't reiterate, but I will say if the court finds it was premature, then we would request a holding that we have a chance to make the motion again after discovery. I did make the motion initially because my client says we were hitting the rear. But the point is there are only two versions before the court below, and the court can't somehow say there must be some third version out there. Under either of these two versions, the counterclaim should be dismissed.
Okay, thank you.
Thank you, Your Honors.
Santiago versus Genting?
Good afternoon, Your Honors. My name is Kevin Murtaugh. May it please the court, I represent the defendant and third-party defendant, United Architectural Metals. Your Honors, I think the main point I want to bring out is the fact that I think that Judge Chan below decided as a matter of law that the Genting defendants are entitled to contractual indemnity as a matter of law. And what I wanted to point out in my brief, Your Honor, is that I think the facts in the case are replete with I know that there's not a negligence trigger in this particular contract. I concede the fact that the Massey the Genting defendants are a customer of Massey's. I concede that. However, that doesn't end the inquiry because The question becomes whether or not, even though there's no negligence trigger in this case, was the accident caused as a result, was there a proximate cause as a result of my client's acts in packing this material and it having been left there some 4 months before in an outdoor setting?
It's even broader than that. It says losses arising out of injury in any way arising out of or caused by the work or services performed or articles furnished. So it covers like every basic scenario. It definitely, this accident definitely had something to do with the crates and the unpacking of the crates, which was what was supplied by UAM.
But Your Honor, I don't. There's a proximate cause argument to any of these indemnity agreements. What I'm suggesting to you, Your Honor, is that you cannot find contractual indemnity unless it's a proximate cause. The plaintiff's expert, Mr. Belizzi, testifies that there are a number of causes that this accident could have occurred. What? The ramp itself, the fact that there was a...
Right, but even if there were multiple proximate causes, as long as one of the proximate causes was the crate, that creates a contractual indemn.
If one of the proximate causes, I agree with you, Your Honor, but what I'm suggesting to you is that is a question of fact. There are numerous facts in this case which would require, at best, that there be conditional indemnity granted to the Genting defendants, because there could be a scenario, and in this...
Usually the conditional indemn has to do with the negligence or potential negligence of the party asserting the claim for indemnification.
Well,
No, I mean, we do often do conditional indemnification, but that comes into play when the party seeking indemnification is an issue of fact as to their negligence. It doesn't come into play the opposite way, what yours seem to be suggesting.
Well, what I'm suggesting here, Your Honor, is that there can be a scenario in this case in which the proximate causes of this accident can have absolutely nothing to do with what we did in the packing of this material. That's what I'm suggesting, Your Honor. And if that is the case, that we should be allowed to, that should be a question of fact for the trier of fact to determine whether or not we did have.
How can you, it's not really a negligence issue, how can you argue that the duty to indemnify was not triggered simply because the accident arose out of the articles that were furnished by your client, which is this is one of the broadest indemnification clauses I've ever seen. It's very broad. And it did arise out of the articles furnished. It definitely arose out of the moving of the crate and the panels.
I still say, Your Honor, that there's a second part of that, and that is that there has to show that it's proximate cause. I think the case law that I cited says that it can't just be arising out, it's got to be arising out of and a cause. And I'm suggesting to you, Your Honor, that there can be scenarios in this case whereby the proximate cause element of this action could very well be as a result of the number of things that we've cited. I know you're familiar with the record, Your Honor. The record is replete with even the plaintiff's experts stating that the fact that the ramp was worn.
No, I don't think anyone really argued that the ramp was the sole cause of this accident, but for the ramp, this accident would not have occurred.
No, if I may, Your Honor, I think they did say, however, that the ramp was worn. They said that there wasn't sufficient personnel to move the crates. There were also, it wasn't tied down. These are things that are, in addition to that, Your Honor, I think they said that they shouldn't have used the skates, okay? And in addition to that, Mr. Eli testified to the fact that these things were out in the open for some 4 months.
But then how does that change the language in any way arising out of? I mean, that, like my colleague said, that's very broad. Even if what you're saying is true, in any way could mean all of those other things.
Well, I can only say, Your Honor, that it is very broad, and it's a very broad indemnification agreement. However, I must stress that I believe that you still must find proximate cause. The inquiry doesn't end if, in fact, it's just arising out of. I would tend to agree with you. However, the case law that I'm citing, Your Honor, I believe that there must be a showing of proximate cause, and that has to be a question of fact in this particular case. Thank you, Your Honors.
Please the court. My name is Scott Singer, and I represent the plaintiff appellant respondent, Mr. Santiago, in this case. As you know, there are three. We have three causes of action that we think that they're there's liability under all of them. Under the common law negligence and labor law section 200 cause of action, I just want to point out that Mr. Eli, or Mr. Eli, who's referred to by by the attorney just now, that he spoke to the on the telephone with the personnel from Massey, and in that he acknowledged that additional securing devices were needed. Because of the fact that the panels were moving around, they were loose inside the crates and they were moving around. And everyone acknowledged that prior to the accident, that additional securing devices were needed. And we believe...
Well, I don't know that they've acknowledged that this particular crate had it moving around.
That's
moving
correct.
around. I don't think they ever conceded that.
There was no specific discussion about this particular crate, but that was, as a matter of practice, it was happening all over the
Right, but
time.
they're certainly arguing that as to this particular crate, there was nothing wrong with it. That's their argument.
Well, there was obviously something wrong with it, and we...
Well, no, what the argument I think he just made is that there was nothing wrong with it, that this accident could have been caused solely because there was something wrong with the ramp, and that, I think he's arguing that was the sole proximate cause of the accident, was that, he was arguing in the context of the indemnification, but
Yeah,
there's an issue of fact as to whether, so what is wrong with that position, that it's possible that a jury could ultimately find that the only reason this accident happened was, if it finds liability, was because there was something defective about the ramp and had nothing to do with the way the panels were created.
Just because, as a general matter, there can be more than one sole proximate cause.
No, I
of the
know, but
accident.
how do we know what the jury's going to decide?
You know, because that's the way they packed the crates. They didn't have enough 2x4s in them. They didn't have enough foam. They didn't have screws that were
And in
affixing the
fact, there
panels.
was, part of the record indicated that there had been some notice that these were packaged incorrectly because glasses were being received and they were damaged.
That's right. They were damaged, and the personnel between Massey and the plaintiff's employer indicated they were alarmed by this situation. They conveyed it to...
Focus on a specific,
Yes.
I mean, because this is a law, we have to focus on a specific cause of action. And you're sort of making arguments about the facts generally, but you're not making specific arguments correlated to the specific causes of action.
Well, so
I would like you to do that.
yes, I would like to do that. First, the fact that there was a problem with the packing, I believe that was a sole proximate cause of the accident. And under...
But how can we decide that as a, you're saying it's a matter of law that was the sole proximate cause of the accident?
was
You're saying
a
there's an
sole
issue-
proximate cause.
Well, you're saying there's an issue of fact.
You can't have more than one sole proximate cause.
No, you can.
You can have more than one proximate cause. If something is
Oh,
sole,
oh,
that
oh,
means
oh.
it's by itself. So
I
there can be
apologize, Your Honor,
multiple proximate cause. It can be, something can be a proximate cause.
Yes, it was a proximate cause. I'm
How
not
have
saying it
you
was a sole
shown as a matter of law, as opposed to raising a factual issue as to the way the panels were created caused the accident to occur? How can we decide that as a matter of law? The fact that there were some issues with how the panels were created before a complaint made, how does that establish as a matter of law that the way they were packed was what caused this accident?
Well, I think it's routinely done if there are multiple proximate causes, as you say, right? There's a PJI 2:70, I think it is. You can have multiple proximate causes, so it was a proximate cause.
Right, no, I understand there's
understand.
multiple proximate causes, but why shouldn't that go to the jury, whether this was either the sole proximate cause, one of the proximate causes, or not a proximate cause at all? How can we decide that on this record as a matter of law? That's what I'm asking you.
I think that it's a practical matter that I think a jury would have to infer that that was a proximate cause of the accident. Could I
You'd
just...
get a directed verdict on the issue.
Yes.
Okay.
Could I just move? I just want to...
We can move on.
I want to touch on the 240 cause of action, partially because he filed the decision today. Judge Kern, you're familiar with it. It's the case Cusimano. It was decided just 2 weeks ago. You were the presiding judge on that bench, I believe. And I cited a case, Ali, against Sloan Kettering, where a coil was being moved by dolly down a ramp, and as it was being moved, it tipped over. Liability was found as a matter of law based on the fact that it wasn't properly.
Well, I'm going to let you respond to this issue in rebuttal, but the issue that you need to respond to in rebuttal is whether the application of the force of gravity was involved. But I'm going to let you respond. I'm going to let you respond in rebuttal because you have a minute.
I would,
You
thank
can
you very
address
much,
it.
Your Honor. I will do that.
Good afternoon, Your Honors. Daniel Cerritos from the firm of Cullen and Dykeman on behalf of the defendants, third-party plaintiffs, Plaza and Genting. Plaza and Genting have appealed the denial of their motion for summary judgment as to 241-6 based on an alleged violation of the New York Industrial Code, Section 23, subsection 1.22b3, in particular the ramp that we've been discussing. Specifically, subsection 3 of that subsection governs this particular ramp because it's a pedestrian and wheelbarrow or similar.
Let me ask you, because the language in that is excessive spring or deflection.
Correct.
How can we decide as a matter of law whether what was described as wobbling by the plaintiff and his coworker does or does not constitute excessive spring or deflection, which was approximate cause of the accident?
Because the skates weren't on the ramp when the accident occurred. The skates came to a stop at the lip. The lip is not where the skates were. So the wheels hit the lip of the ramp, came to a stop, never made it onto the ramp. So if there's any deflection, any spring, any wobble on the ramp, it never affected the skate or the crate that contained the panels that were on those skates, because those wheels never made it onto the ramp.
And just to finish that, I guess, thought to its logical conclusion, because the front of the ramp, if it was raised or anything like that, caused the skates to stop, that's still not excessive spring or deflection.
Correct, because the lip itself is what stopped it, not that there was any movement on the actual body of the ramp, which would be where the provision would come in to prevent excessive spring or deflection. So based on the testimony here, we don't even get to this specific provision. This provision cannot be approximate cause of the accident. So it was improper to deny the summary judgment motion simply on this one provision, which is the one provision that was permitted to proceed. So
was there a lip, or was there a gap?
There was a lip
between a lip, not a gap.
There was, but even if there was a gap, it would come to the same conclusion because the skate would still not be on the body of the ramp, so there wouldn't be any excessive deflection or a wobble that would have caused anything on the skates to fall off. So again, the provision would not have been approximate cause of the accident.
There was, and there wasn't any testimony by the plaintiff as to wobble, that it actually made it on and it wobbled?
He never testified that it made it onto the ramp. No witness ever testified that it
So
made it
how
onto
did
the
the
ramp.
wobbling come up? Because he clearly testified as to wobbling and that he thought the wobbling was one of the causes of the accident. Why would he say that if the never made it up to
Because the testimony is, and it's, everyone agreed, the skates, the front wheels of the skates hit the lip, came to a stop, then supposedly even if there was a wobble on the ramp, that still didn't cause the incident to occur because the skates stopped. They never made it onto the ramp. But at that point is when the incident occurred. Because the momentum of the skate stopped, the panels within the crates kept on moving, broke the panels, struck the plaintiff, causing the incident. So again, it's horizontal movement.
Thank you.
Thank you, Your Honors.
Again, Your Honor, if I may, just in response to what my colleague was saying in his statement, we don't concede that these packages, these crates were improperly packed. What we did say is that we of course had, we assigned this Larson Engineering to specifically tell us how to package these crates. We think they were packaged properly. There's evidence in the record which shows that this these lulls that were taken may very well have been the incident which caused these loosenings. We don't deny that, Your Honor. But what we do deny is that they were improperly created. Certainly the fact that they moved around could certainly have been as a result of this excessive movement and the fact that they were outdoors for 4 months. So what we're saying is we never did concede. Mr. Eli was there the day after the incident and said, I think it was as a result of this particular movement. That's all I have to say with regards to that, Your Honor. We don't concede that these things were improperly packed. Thank you, Your Honor.
I have a fair number of things to say in a minute, so to try. But let me just respond to what Mr. Murtaugh said. I'm not saying he conceded. I'm saying Mr. Eli conceded. If you read his testimony, it's very clear that it required the panels were loose and they required additional securing, and that had to be remedied. And everybody agreed that. So I think that point is conceded. I want to answer, Justice Kern, your question about the gravity.
Well, first, before you get to that, did the plaintiff testify that this dolly made it onto the ramp, or did it stop at the lip? Was there any testimony about that?
It was he and the other people that testified. It was very confusing what the exact sequence of advice of events was, but he was very clear that he felt that the ramp move and wobble, and that's when the panel became dislodged. That was the sequence. He felt it move and dislodge. It seems to me likely that the part of two of the wheels of the skates were actually on the ramp at the time. And I think
quickly make.
Yes.
Do you have more questions about the wobbling? I'll let you quickly make a statement about the gravity.
Yes. Assuming arguendo, as their expert, Ms. Kennedy, stated, that there was initially a lateral movement, a horizontal movement, that caused impact with plaintiff's hand. Plaintiff nonetheless testified that the entire panel fell on him. It hit him across his entire body, causing him to fall to the floor. And that was supported by Travis Freeman. So there was evidence to support a 240 violation. Thank you very much.
Hernandez versus Piccardo.
Your Honor, I thought I had a...
Oh, I'm sorry, you do. You have another minute. I thought you said everything you had to say there.
No, just on the appeal. In response to the gravity issue, Judge, key here would be the fact that the photographs, which all the witnesses testified were a fair and accurate depiction of the way the crate, panels, and skate looked immediately after the accident. The panels were still in the crates were still on the skates. Nothing was on the ground. So, by that testimony, nothing was driven by gravity to the ground. So nothing would trigger label law 240 subsection 1 here.
Thank you.
Thank you, Your Honor.
Hernandez versus Piccardo.
Good afternoon, Your Honors. May it please the court. My name is Wayne Greenwald. I'm here on behalf of the appellant's defendants. This appeal is from an order granting re-argument from an order.
Let me start from the end first.
Forgive me.
If we agree with you that the judgment can't stand because counsel was not in good standing at the time the judgment was vacated and couldn't practice law.
Section 321.
What happens then? What happens to this case?
What happens to this case?
Right, because if the judgment was vacated, then we can't get to the merits of the underlying.
I would say it should go back for trial.
But there's still already, because there was counsel who was in good standing at the time the decision was entered, granting the motion to re-argue, that's where we are in the case.
Understood.
That being the law, so all they would do is go ahead and enter another judgment.
I'm not quite sure what I'm not quite sure what disabilities he may have been acting under at the time.
Right, but that's not
before.
in the record
I
before.
appreciate that. I understand that. That offhand, I would say that it should go back and be tried. I appreciate the fact that there is the decision. However, again, the re-argument should never have been granted because there was the re-argument motion doesn't indicate there was anything overlooked. And not only did it not show there
Your
was
time
anything,
to appeal from the re-argument motion has already lapsed, right? I mean, even if you had an argument that could have come up with the judgment, by virtue of us, if we agree, vacating the judgment, all you have then is the last decision with the re-argument, and your time to appeal from that determination, you can't appeal it anymore.
well, we have two thoughts here. Number one, the argument that the time expired is based upon the thought that the order was a final order. However, the order was an order granting re-argument and then granting summary judgment. An order for re-argument anticipates that something is going to happen afterwards.
Time to appeal runs from service of the order with notice of entry.
Understood.
And Mr. Altman, it appears, served you or your predecessor on January 7th, 2023 with notice of entry of the re-argument order.
Right, but the re-argument order is not a final order.
Right, most of the appeals we hear are non-final orders.
In which case, the argument here was that the time to appeal lapsed because it was a final order. When the order was entered, which meant the judgment was entered, we then took the appeal. I mean, I did not.
Meaning you'll get another shot, once the judgment is entered again, you'll get another shot to make these arguments again.
It would seem so, yes.
Then you'll appeal from the judgment again. If we vacate this judgment, at that point, it will come up as part of that.
I would say possibly so. Mind you also, there, as far as vacating the judgment, even if I was not able to go to trial, and I was stuck with the motions for summary judgment being granted as opposed to being granted relief from the order itself, the judgments themselves, that if relief from the judgment and the order granting summary judgment is granted, and let me backtrack for a second, forgive me. If relief from the judgment is granted and the judgment is vacated, then the defendants may have other options, not necessarily involving state court as well. So that is important.
Okay, so why should we get to this issue since you raised it for the first time in your reply brief?
I'm sorry, forgive me?
Why should we get to this issue when you raised it for the first time in your reply brief?
Well, because, number one, it doesn't matter, as the authority cites, it does not matter if it's raised for the first time on appeal. We cite authority to that effect, that it can be raised at any time, even on appeal. And I will confess that I became aware of it when the plaintiff raised the issue of the untimeliness of the appeal, and we were looking at what role the defendant's counsel becoming disbarred or incapacitated played, and it was at that point we saw Section 321. So there would be, there appears, based upon the law, a mandate that judgment has to be vacated. While the other two orders might not have to be vacated, well, I believe it would be appropriate for them to do it, which is why I'm arguing. But based upon the authority, the judgment has to be vacated.
Thank you very much.
Your Honor, thank you. Any other questions?
No, you'll have time to rebuttal if you want to address anything.
Okay, thank you.
Good afternoon, Your Honors. May it please the court, my name is Joseph Altman. I represent the respondent on this appeal. What we have here is a defendant who defaulted, clearly defaulted. There is no defense to this case.
Can you speak?
I'm sorry, there is no defense to this case. And grasping at straws procedurally within this.
Counsel, why should we not accept the argument raised on reply that there's no basis for this judgment to be upheld because counsel was disbarred before the judgment was entered, and therefore everything was stayed automatically. And there was no basis for the case to go forward at that point.
Well, number one, he did raise it for the first time in a reply.
Right, but if it's a jurisdictional issue and the cases do seem to support that, we still need to address it.
Number two, it's somewhat the entry of the judgment is just a simple ministerial act. What the real decision here was a decision.
I just want to clear what I said. I said disbarred, but it was suspended.
Yeah, I had another case with Mr. Gross when I remembered he later on was suspended. But in any event, the entry of the judgment is somewhat irrelevant in this case. It's just
Yeah, but the law says that judgment, if he's right, the judgment could not be entered. So what choice but we have then to vacate, and then the case will proceed however it proceeds without the judgment in place. And you could then debate what will happen to the rest of the case.
Well, because the judgment has nothing to do with the findings of the court. If you vacate the judgment, then all we're going to do is put in another judgment now that there is an attorney who's not disbarred.
But then we can get to the merits of the argument. If you put in another judgment and he then appeals it, that will bring up the underlying order, and he'll get to argue that the court erred in its determination.
But you're not really appealing from the judgment.
Yeah, but a judgment, the final judgment brings up everything that came before it. Well, that's one of your arguments, but we're not going to get to that in this case. If we vacate the judgment, it'll have to be saved for another day, that argument.
Right, but what I'm saying, Your Honor, even if you did vacate the judgment, you can just re-enter the judgment, and you still on. And as Justice Higgett brought up, the actual issue here is the granting of the motion to re-argue by Justice Soto, and that's where the motion was granted. It was determined that.
Right, but I don't think we can. I don't think if we agree that there was an automatic stay when the judgment is entered, I don't think we can reach those issues in this appeal.
Well, that should have been raised in the initial set of papers, not in the reply. And again, there's something called harmless error. I'm sure the panel is aware. In this particular case, the judgment herein has nothing to do, just another way to further delay a case that started in 2010 and took forever to get to the end, to get to a final judgment. If you vacate the judgment, you're still not going to vacate the decision and order of Judge Soto.
But counsel, Mr. Altman.
Oh, yes, Your Honor, sorry.
It's okay. You would agree that the right to get substitute counsel within a given amount of time is sacrosanct, wouldn't you?
Not in this particular case, Your Honor, because it had nothing to do.
Where do we, if you say not in this particular case, where do we draw the line?
Well,
Those 30 days, how long do you get to find substitute counsel?
how long do you get to find substitute counsel?
Right.
When an attorney, well, here, Your Honor, you had the notice of appeal. The time expired on a motion to re-argue. So the fact that Mr. Gross was suspended for some period of time is irrelevant to the additional time that they're looking for to appeal. So that's why I say it's just another roadblock that they come up with to say that, A, we didn't make a prima facie case in the underlying case. They were precluded. Vacating the judgment and giving him more time is really not what should be done in this particular case. I mean, you have to look at the facts in this case. Did not having an attorney, if they had an attorney, what would have been the difference?
Thank you.
Okay, thank you, Your Honor.
I'll be very brief. One, the entry of the judgment is not irrelevant. Giving entry of a judgment opens up a world of rights to a judgment creditor that don't have before then. Two.
I think the point is, or the argument is, The entry of judgment here was a purely ministerial act. And I guess the question is that accurate or not?
I can't say it was because it ultimately resulted in determination of what the attorney's fees were. There was one of the things that was referred to the inquest clerk was attorney's fees, which
20
is a
versus the
tribal issue of fact.
15%, right? The 20 versus the 15% formulation?
Potentially, yeah. And even though there's a percentage, it still has to be reasonable under the circumstances. Somebody has to determine that, even if it's a percentage. Giving a 20% attorney's fees for something that took 5 minutes worth of work may seem improper. I'm not saying the amount of time was taken or not, but I'm just saying it's quite possible that it is not a ministerial act there.
Thank you. Thank you very much.
Okay, thank you, Your Honor.